Morning, everybody, or I should say good afternoon. So thank you for everybody who's logged on today already. And I think we had a few more registrants that had signed up for the webinar. So I'm going to wait just one more minute before we dive into the presentation. But again, thank you for signing up for the webinar on trusts, or what I call Trust 101 for today. We do have some webinars, additional webinars coming up in the next couple of weeks. So if you're at all interested in those, please visit our website where we have information again about all the upcoming webinars. So we'd love to have you jump on just because we provide what we feel is a lot of good information, at least when I'm doing the presenting on estate planning topics, probate issues, elder law questions. So we're more than happy to continue putting on these webinars for you all. And actually, if anybody has requests for webinars they'd like to see, or topics they want to have discussed, or specific questions that they have, you can always feel free to contact us directly through our website again to provide us with those comments or suggestions, because again, we really do like to tailor these webinars to you the best we can. So it looks like we've had about one or two more people jump on here. So just in the interest of time, we're going to get started. So as I mentioned, today is Trust 101. So the number one question that I get from a lot of folks is, what is a trust? Because there's a lot of folks out there who give presentations saying kind of, this is what a trust, you need a trust, or you see these infomercials that say, you know, log on to our website, LegalZoom, we have trusts that they're going to work for you. But without really explaining what a trust is, what it does, when it might be beneficial. So very simply, the way I always describe a trust to my clients is to think of a trust as a bucket. A trust is a legal bucket that we create with a 10 or 15 page document or so. And once you sign that document, your bucket is created and you can start putting assets into your bucket. So again, it's a bucket that's designed to hold title to your assets, to own certain amount or certain assets of yours. And again, I'm going to get into the specifics as to why you would want to do that. Again, what types of assets you should be putting into your bucket as we get into the presentation a little bit. But again, just from a very basic standpoint, trust is simply a way to own assets. You can put almost any asset that you have in your trust or in your bucket. So we see a lot of people that do real estate in their trusts, or put bank accounts in trust, even cars, life insurance policies. All of these types of assets can go in your trust. One of the few exceptions we see for assets that can't be transferred into your trust is retirement accounts. So IRAs, 401ks, 403bs, all of these what we call qualified retirement accounts. When I say qualified, that it really just means those are pre-tax accounts. You haven't paid any income tax on those accounts yet. Amounts that were funded into those accounts were taken right off the top of your paycheck, put into those accounts and allowed to grow income tax deferred. And you really only start paying income tax when you start pulling those assets out when you retire. So I'm not going to get too much into detail about that because that's a topic for a whole nother webinar. But for today, again, those types of assets, those qualified retirement accounts are probably one of the exceptions to the rule that you can transfer most anything you own into trust, because those qualified retirement accounts need to still be individually owned by you, and you can't typically name the trust as the owner. So now that you have a trust, or again, you may be interested in say, okay, I understand that a trust is a way to own assets. Again, when might it be beneficial to have a trust and put assets into it? So the first remark I get from a lot of folks when I start talking about trust is, I don't think I need a trust because I don't have millions of dollars. And so I find that's a really common misconception. Folks tend to think you need to have, mega millions. Really, only the uber wealthy are the people that would really benefit from trusts. And that's not necessarily the case. It's really a case-by-case situation. So yes, do trusts make sense for very high net worth folks? Sometimes yes. Do I have clients who are not super wealthy who also get a lot of benefits from trust? Absolutely. So it's not necessarily a determination. So you look at your balance sheet and how much stuff do you own. That's not really going to be the determining factor as to whether or not you need a trust necessarily. Again, it really depends on what you're looking to achieve. So what are your goals? Where do you want assets to pass upon your death, or how do you want them to be managed? Those are really the determining factors as to whether or not a trust might make sense. So the number one reason I see with clients who opt for trusts and think it's going to provide a lot of benefit for them is for people who are looking to avoid probate. And that's actually all of my clients. I have yet to meet a single client who says, yes, I want my assets to go through probate. Just because probate is a very long, involved process, not a bad process. It serves a valid purpose, but it can take a substantial amount of time. So why would you want to tie assets up in probate after you pass when you could potentially simplify things a whole heck of a lot by having those assets pass your beneficiaries outside of probate? So that's one benefit you can get with a trust. I should also to back up and say, and this was in the initial description of the webinar, there's two general types of trusts: a revocable trust, sometimes also called a living trust, and an irrevocable trust. I'm primarily for this section focusing on revocable trusts, but a little bit later on in the presentation, I will get into a description of what's the difference between the two. But for right now, I'm primarily talking about revocable trusts. So again, the number one benefit for a lot of folks is that revocable trusts are going to avoid probate. The second most common reason I see people opting for trusts is when their beneficiaries are minor children, or beneficiaries who are of age, so they're 18 years old or older, but just not really great with managing money. Again, either because they're still on the younger side, so maybe they are only 18 or 19 or 20, and the thought of them inheriting a big lump of money maybe doesn't inspire you with a lot of confidence. And you say, you know what, the odds of them maybe mismanaging these monies or just spending it all immediately is pretty high. So you don't really feel comfortable with just, your beneficiaries getting a big check outright. Trust can provide delayed receipt of inheritance. So it essentially says, regardless of whenever it is that I pass away, I never intended for my beneficiary to get an inheritance until they were age 30, until they're age 35, or maybe for their lifetime. I don't think they're really ever going to be capable of managing maybe a larger inheritance or any inheritance. So I kind of always want somebody keeping eyes on it and managing it for them. So again, that applies typically to most times to minor children, but again, also in certain circumstances to beneficiaries who again aren't very financially mature. So again, you can write those rules and again say, and I kind of arbitrarily picked a couple ages there, and 25, 30, 35, but trusts are customizable and you can choose really whatever age that you want. So again, if you've passed away and your beneficiary and you've said, well, I never wanted my beneficiary to get those assets until they're 30, and they're 25 when you pass, then those assets are going to be held in trust. They're going to be managed by a trustee who's making sure those funds are invested properly. But then the trustee also is going to have discretion to still use those funds for the benefit of your beneficiary. So those assets aren't going to be tied up and inaccessible to the beneficiary. So the funds can still be used to pay for college and grad school, or help buy a house, or start a business, pay for a wedding. Really anything and everything that the trustee, the person in charge, if they feel it's appropriate to make a distribution, again, for whatever reason, they're going to be allowed to do that. So the beneficiary is going to have access still to that inheritance that you've left, but just through the trustee as a gatekeeper, again, kind of making sure there's someone that still has general oversight and management over those funds to make sure they're being managed appropriately. So that applies, again, to minor beneficiaries. It applies to financially immature beneficiaries. Can also apply to beneficiaries who are at high risk of having creditors. So somebody maybe who's in a high risk profession, like a doctor or a lawyer, somebody who may get sued just by virtue of the work that they do. That's maybe a reason why that type of person you would want to leave their inheritance in a trust instead of giving it to them outright, to maybe protect those assets from any creditors that may try to come after them and take all of their assets, which now is going to include the inheritance that you're leaving them. Or somebody that's maybe going to get divorced. So when I say creditors, a lot of people kind of don't think about the divorce aspect, but if you love your son dearly, but really, for example, don't like his wife, and you think that their marriage isn't really going to last for the long haul, do you really want to leave an inheritance to your child outright, knowing that half of it may soon pass to your child's ex-spouse? So again, if that gives you a moment of pause, again, it may make more sense to, instead of leaving inheritance to that child or to that beneficiary outright and have it again come up on the chopping block in the divorce, instead, again, you have that child's or beneficiary's inheritance held in trust and just managed for them for a period of time. Also, too, trust can make a lot of sense for disabled beneficiaries or beneficiaries who are receiving Medicaid benefits. With a lot of state and federal assistance programs, like Medicaid being the most common one that we see, you have to meet certain eligibility requirements typically to receive Medicaid benefits. And it means that you have to have no real money or assets of your own. So if you have someone who's receiving health insurance or rental assistance or any type of funds, again, through Medicaid or other state or federal benefit programs, if they all of a sudden receive a large inheritance, that could jeopardize their continued eligibility for those benefit programs. They may become ineligible. And now all of a sudden that inheritance that you left them has to just immediately be spent down so that they can become eligible for those benefit programs again. So again, if that's really not a desirable result in your mind, assets can still be left in trust for that beneficiary. But there's a specific type of trust that we say, well, money is being left for this beneficiary. And again, they'll be able to have some level of access to it through the trustee, but it's not going to jeopardize their eligibility. They'll still have continued Medicaid eligibility because of the way the trust is set up. And this type of trust is called a special needs trust, also sometimes referred to as a supplemental care trust. And the reason why you get that benefit, or I should say the beneficiary is going to be able to have the benefit of that inheritance, but still retain their benefits, their Medicaid benefits and such, is that the purpose of the trust and the way the trust is structured is to say that the trust isn't there to pay for things that your beneficiary is already receiving benefits for. So again, in one of my prior examples, I had said, if your beneficiary is on Medicaid that's how they receive their health insurance, then the trust is going to say that's not the intent. The intent of the trust is not to pay their medical bills. If they're already getting those benefits provided to them through Medicaid or again, another program, the trustee is not allowed to make distributions for those reasons because they already have their benefits covering that. The purpose of the trust is to pay for anything above and beyond what the benefits don't cover. So even, for example, if they're receiving health insurance through Medicaid, but they need some very specialized dental work, or they need something more than the basic, something that's not going to be covered by their health insurance benefits they're getting through Medicaid, that's something that the trust could pay for. Or if they need help paying for rent and buying groceries, and again, they're not on a benefit program that's providing that type of assistance to them, the trustee can pay for those things. Again, so the purpose of this type of special needs trust is to pay for anything and everything that their benefits, the beneficiary's benefits are not already paying for. So again, it's kind of just another way to still be able to leave an inheritance for a beneficiary, again, who's on an assistance program like that, while still allowing them to maintain their eligibility for those benefit programs. Kind of the last example I'm going to give where I think a trust can make a lot of sense is for blended families. If it's a second or a third marriage or more, and you and your spouse have children from prior marriages, or even if you don't have children, but you say, I had always intended my assets, my 401k, my house, all those things pass to my family, pass to my siblings, or pass to these charities that I like to support when I pass away, and not to my spouse's family. We kind of, if it's a situation where you and your spouse like to keep your financial assets separate, the trust can assist you with that. So to give you an example, I recently met with clients who had that exact situation. They didn't have any children, but they did have brothers and sisters and nieces and nephews and other family members that they ultimately wanted to receive their individual assets. They still wanted, though, to provide for their spouse upon the first of them to pass away. So when spouse one passes, they said, I want my surviving spouse to still be able to be the primary beneficiary and still have access to my assets to help pay for everyday expenses, paying for the mortgage and paying for, they want to take a trip, just generally having access to those assets. I want to leave some money to them, but then when my spouse passes away, I want to make sure those assets, again, get directed to my family and not my spouse's family. That's one thing that a trust can do. We can set it up so when you pass, the assets are going to be retained in trust, in what we call a marital trust. That's exactly as I described. It's for the benefit of your surviving spouse. And often it's even the surviving spouse that's going to be the trustee of that marital trust. So they're going to be in charge and have the access to those funds. But when the surviving spouse passes away, again, those assets are now directed to your family and not your spouse's family. So again, that's something that I've seen fairly common, and again, gives people a lot of peace of mind, because one of the common concerns, particularly if you have a fear of if one of the spouses were to pass away and the surviving spouse is still relatively young, there's a high probability that that surviving spouse could get remarried. So the thought of saying, well, if I just left it all outright to my spouse, and the spouse then, goes and marries the pool boy and changes their will to say, I now leave all of my assets to my new spouse, you've now effectively cut off your family, or the people that you ultimately really intended to have those assets after the surviving spouse passes away. So again, this type of trust allows you to really have a little bit more control. And with all of these trusts, that's exactly what they do. They allow you to have more control. They allow you to still write the rules for how these assets are going to be managed, even if you're no longer here. So that's really the true benefit of the trust, is if you still want to have some control over what's going on with the assets, trust will definitely give you that. So as I mentioned, there's primarily two different types of trusts, revocable and irrevocable. Revocable are tend to be more common in the ones that in estate planning context for the reasons I talked about. So setting up revocable trust to kind of make sure assets are managed not only appropriately during your lifetime, but for your children or other beneficiaries after you pass away. So, and again, I find that's the most common. We do revocable trusts most commonly, but there are irrevocable trusts. And as the name implies, or I should say the names imply, the primary difference between the two is that revocable trust, you're free to change that at any time. You can take if you set up a revocable trust, you're likely the trustee. So you're the person in charge. So you're directing access and control and investing decisions. All of that still is going to fall under your purview. And then if you've set up trust for children or other beneficiaries, or directions for what happens to your assets after you pass away, and a year or two later you change your mind, you can always rewrite that trust. You're able to revoke it, amend it, change it in any way during your lifetime, again, so long as you're competent to do so, because it's a revocable trust. The irrevocable trust is the exact opposite. I tell my clients, you might as well, if you prepare an irrevocable trust, once you sign it, you might as well essentially consider it carved in stone, because those are the rules. You only get to write them once, and then you don't get to change them. And also typically, and I'll get into the reasoning why this is in a moment, with the irrevocable trust, you're likely not the trustee, you're likely not the beneficiary. So it really means you've now cut yourself off from any assets that are owned in that irrevocable trust. So irrevocable trust can make sense. Revocable trust can make sense. It really depends on your personal situation, because there's really pros and cons to each. I would say, again, the primary reasons we do revocable trust more often is just because of the flexibility aspect. If you still want to be able to retain control and management over your assets during your lifetime, but just want to provide some safeguards for beneficiaries after you pass, then the revocable trust is likely a good way to go, because it's going to give you that flexibility and allow you to modify it if things change over time. A downside, though, to doing a revocable trust, because you have so much access and control over those assets, there is no creditor protection for you during your lifetime. So I mentioned when you can set up a revocable trust if you have beneficiaries who might have creditors. So after you pass away, if you have a child that's going to be divorced or is bad with managing money and has lots of people banging on his door to pay them, your beneficiaries get creditor protection. You, during your lifetime, because you're the trustee and you're in charge and you really have no restrictions on your ability to access assets in trust, you do not get creditor protection. So that means if you have back taxes that are owed, the government can come after assets that are owned in trust. If you have someone sues you and gets a judgment against you, they can come after the assets in your trust. If you have long-term healthcare costs that you need to pay for, assets in that revocable trust are not going to be protected from those types of costs either. So, for example, if you need long-term care and you need to go into a nursing facility and are looking to apply to Medicaid to pay for those costs, you still, by putting assets into a revocable trust, you haven't protected them from that. Typically, you would still have to spend down all of those assets before you're going to be eligible for Medicaid. So that's really the downside. Probate is going to be avoided with a revocable trust. You're going to get lots of protection for your beneficiaries after you pass, but during your lifetime, there's not a whole lot of protection there, again, from your creditors. But there's lots of flexibility. With the irrevocable trust, again, no flexibility. Once you write the rules, you can't rewrite them, you can't change them. So if you write the trust today and 20 years from now, those trust rules don't make a whole lot of sense anymore, you're stuck with them, or I should say your beneficiaries are going to be stuck with them. So really no flexibility. But it's the opposite of the revocable trust because there's no flexibility. And as I mentioned with the irrevocable trust, typically you're not going to be the trustee, so you're not in charge. You're likely not going to be the beneficiary, so you're not going to have access to any of those assets in the trust. You do get some protection from creditors. So I typically use, when I'm talking about creditors, I use Medicaid as a big example of that, because as a lot of folks get older and they need long-term care, if you need in-home caregivers, if you need to go into a nursing facility, that care can get really expensive really quickly. So a lot of times people say, well, I want to protect my house, I want to protect these other assets. So irrevocable trust may be a way to do that. You can put assets in an irrevocable trust, and so long as you put them into the trust more than 5 years from the date you need to apply for Medicaid, those assets are going to be protected. And again, the state is not going to be able to come after them because, again, the purpose of the irrevocable trust is you really put a wall in between yourself and those assets. You gave them away. They're not yours anymore. You're not in control of them. And so that's why you are going to get creditor protection with irrevocable trusts. But again, there's the loss of flexibility. And actually one situation I saw once with folks who many years ago set up an irrevocable trust because at the time tax laws were different and their family situation was different. So the irrevocable trust made sense. And one of the assets that they put in the irrevocable trust was their house. 20 years later, they now decide, well, we want to move to Florida, so let's sell our Connecticut house and move down there. They're not able to do that because they're not the owners of the house. Their kids are the owners. So what had to happen in that case, and again, we were able to achieve some type of beneficial result for the clients, but typically what's going to happen in that case is that even if your child, again, is the trustee of that irrevocable trust, for example, and they say, okay, yep, we agree, mom and dad, we're going to sell the house. If the house is sold, even though it's your house that you've been living in, you don't get the benefits of the sale. You don't get those sale proceeds and can't necessarily use them towards purchase of your new house in Florida because those assets are owned in trust. You gave them away a long time ago, so they're not yours. So again, I don't say this to say, all trusts are bad, because there's all these bad things that can happen with revocable trust or benefits you're not going to get with a irrevocable trust. There's pros and cons to each. And again, it's really just weighing those to see, does a revocable trust or an irrevocable trust make sense in your circumstances, looking at the specific issues that you're trying to tackle in your plan. So I would say there's a lot of common pitfalls that I see with folks who do decide to go with trusts. The number one issue I see most commonly is that clients see us, we have a meeting, we discuss trust, and they say, yes, this makes a lot of sense. I think it's going to provide a lot of benefit. So we set up a trust, they sign it, and they have this revocable trust in place. And maybe the primary goal there is probate avoidance. They want to make sure their spouse, their kids, their beneficiaries don't have to sit in probate court for a year before they're going to get those assets. But then after we set up this trust for them, we set up their bucket, they never put their assets into the trust during their lifetime, which is a problem. That's how you're going to get probate avoidance. In order to achieve that result, you have to retitle assets into trust during your lifetime, because the assets at the time you pass, your assets have to be owned by the trust in order to avoid probate. So I've had many, many clients who, again, we set up this trust and we say, okay, we can assist you with putting assets into the trust, but for the most part, it's your responsibility, it's your homework. And again, kind of let us know if you need help. And we periodically follow up and check in with them every couple of years to say, have you funded your trust? Have you put your house in there? Have you retitled the bank accounts? And many years later, when they pass away, come to find out they never did any of that. So they set up this trust for probate avoidance. And instead, all of their assets are still passing through probate just because they never took the additional steps to actually fund their trust. In one instance, too, where I saw a particularly bad result is where clients owned not only their house in Connecticut, but they owned a vacation property up in Maine. And when you have assets, again, that are individually owned, so upon the second spouse to pass away, the surviving spouse, or if you own real estate, I should say, in your own name, and you own it in multiple states. So if you have a Connecticut house and a Maine house, when you pass away, you have to do a probate here in Connecticut for the Connecticut real estate. And now you also have to do a secondary probate, what we call ancillary probate, up in Maine too. So you get two probates for the price of two. So it's going to be a long drawn out process now in two different states. And it's going to be probably expensive if you're hiring attorneys and you have all this other stuff that you got to do just because those assets never got placed into trust during your lifetime. So again, I can't stress it enough, just because it happens so commonly. Assets really, if you have a trust, you really need to make sure you stay on top of how you own your things, because you want to make sure to a large extent, most of your assets are owned in trust at the time you pass. Or you want to make sure that your beneficiary designations name your trust as the primary or contingent beneficiary of assets. So the 401k or the life insurance or investment accounts should name, like if you have a trust, it's likely going to make sense to name the trust as a beneficiary of those accounts at some point. And with married couples, typically we say it still makes sense if you still want your spouse to have all the assets immediately upon the first of you to pass away, it still typically makes sense to have the spouse be the primary beneficiary on those assets. So that can make this probably remain the same. But if you have trust for kids or grandkids or, again, other beneficiaries, you're likely going to want to make sure the trust is named as the contingent beneficiary. So again, the big takeaway, make sure you have any assets that need to be owned in trust. Specifically, real estate tends to be the big one. You need to be mindful of how you own those assets and make sure it's actually owned in trust. And to keeping your beneficiary designations updated to make sure, again, those assets are also going to be passing into trust. Because if you want your assets to be managed under your trust rules, you have to direct all your assets end up in trust. So again, just keeping on top of those things. Also quickly too, and again, I know we're running out of time here, so just very briefly, if you have an older trust from many years ago, you may be able to simplify it and maybe more complicated than you need, just because the big reason why is over the years, tax laws have changed. So more complicated trusts made sense in the past just because different tax rules. And we're seeing a lot of people with these older trusts from 10, 15, 20 years ago that are coming into us and can simplify. And it's going to, again, make things not only easier for you, but easier for your beneficiaries if you don't need that complexity anymore. So if you have an older trust, having it reviewed just to make sure it still makes sense for you, because you may need to update some rules. And also keeping aware or making sure you know who you've appointed to be trustees of these trusts. Because again, trustees are the people in charge of making sure all the assets are invested and managed and distributed out to the beneficiaries appropriately. So if you've named people that have now passed away, or again, maybe you set up trusts for the kids when they're little, but now that the kids are older, so maybe it's the kids that you think should be in charge because they're responsible and they can handle these types of things. Or even if you had previously, again, many years ago, you named a local bank, or you named who was then your current attorney, but now banks have merged and the bank you chose doesn't exist anymore, or you're now using a different attorney. All of those types of things, again, be mindful of who you've chosen to be in charge of your trust, because those things may change over time. And last but not least, if you move from one state to another, so you're previously living in another state, you moved to Connecticut, we always recommend out-of-state documents be reviewed by an attorney in the state you're living in. So again, if you were living somewhere else and moved to Connecticut, you should have those documents reviewed by a Connecticut attorney, just because different states can have different laws that could impact how your trust is going to function, and vice versa. If you have a trust in Connecticut and you move to another state, it may be perfectly fine, but it may not, depending on the specific laws of the state that you've moved to. So we always, again, recommend that an attorney in the state in which you are currently living should always review those documents to make sure, again, they're still functioning the way you had intended. So that's really all I wanted to go over with you today. If anybody has any questions, please feel free to use the chat feature down at the bottom of the screen here. Or you can also raise your hand. That's a feature there too, so I can call on folks if they wanted to speak or ask a question. So again, I'll give folks a moment in case there's anybody who has a question they wanted to ask, either about something that I talked about today, or if there's something that I didn't cover that you have a question on, please feel free again to type it into the chat box. Also, if you think of a question after the webinar is concluded for today, again, please check out our website, kkc-law.com. You can always get my direct contact information, and you can send me an email or give me a call. I'm happy to answer any follow-up questions. And then again, too, we also have information on upcoming webinars. So we're going to be, over the next few weeks, we're going to be addressing some additional topics that I think are going to be really beneficial. So please keep an eye on upcoming webinars that we're going to have coming up. So, and again, all that information is going to be on our website. All right, well, I don't see any questions coming in. So I guess that's where we'll end for today. Again, thank you all for joining, and please, again, don't hesitate to reach out if there's any follow-up questions. Happy to speak with anybody who has questions about trusts or other general estate planning issues. So thank you, everybody, and have a good day.